I work at Lowenstein Sandler. I'm an associate in their bankruptcy and restructuring department. I joined in January 2020. Before that, I was at a smaller law firm in the bankruptcy group. At Lowenstein, I mostly represent creditors committees, post-confirmation fiduciaries, such as liquidating trustees or plan administrators. But we do also represent individual creditors. We do some class action plaintiffs in bankruptcy, and as well as the occasional debtor case. And I started my career right out of law school. I clerked for the Honorable Rosemary Gambardella in the Bankruptcy Court for the District of New Jersey. So we were finding at my firm and in some of our engagements that bankruptcies over the past year or so were moving much quicker. Debtors were entering bankruptcy with the hopes of confirming a plan very quickly. And it doesn't give the committee a lot of time to investigate. So it's something that needs to be looked at immediately. And in certain cases, if you don't preserve the right for the post-confirmation fiduciary, it's completely waived. So it's something that deserves attention at the outset of the case. And it's something that needs to be investigated as quickly as possible. Well, if it's an affiliate or an insider, they often will get a release in the plan, which would preclude any party from pursuing that after confirmation of the plan. A creditors committee or a post-confirmation fiduciary's primary goal, or one of their primary goals, is to maximize recovery for creditors, particularly unsecured creditors, in my practice. And one of the key tools in that, in maximizing recovery, is to investigate and bring fraudulent transfer claims. A fraudulent transfer claim is any transfer that's made either with the intent to defraud creditors or for less than reasonably equivalent value, that made the company insolvent or as the company was insolvent. And normally we think of those transfers as real property, as money, other assets, but debt cancellation or loan forgiveness is a transfer that could render a debtor insolvent. So if you consider a situation, for example, of a company that's making loans to affiliates or other insiders, maybe directors and officers, in the ordinary course of business before bankruptcy, that might be fine. But when you fast forward, a problem could arise when that debt is written off. Maybe it's and a receivable is deemed uncollectible, or otherwise the loan is forgiven. And then the debtor, the company that made the transfer, files for bankruptcy, while its affiliates don't. So the affiliates go on their merry way. They've received a windfall. They no longer have to repay this debt. And the creditors of the estates are left holding the bag. So not only does this feel unfair, but it's a fraudulent transfer that could be unwound to bring recovery to creditors, and sometimes substantial recovery. I think if it's not disclosed in the disclosure statement or in the schedules, you would have a real problem. But I think the problem more arises, and what I've seen is the receivables are disclosed, but they're deemed uncollectible, and that you need further investigation into why they're uncollectible and if they're actually uncollectible. It doesn't help anyone if the loan is actually uncollectible, the receivable is uncollectible, and you pursue it, because the estate or the trust or whatever entity would only receive the right to collect. They wouldn't automatically receive the funds that could be collected, but they receive the right to collect. And if it's an actually uncollectible receivable, it's not worth pursuing. Sure. So I think that's part of what would make it a fraudulent transfer. That would be an actually fraudulent transfer if it was deceptively deemed uncollectible. But other times it's really the committee or the post-confirmation fiduciary's job to understand what that investigation was. And I think it's a question that needs to be asked is how did you deem it uncollectible? Because you don't necessarily have insight into the books and records of the non-debtor affiliate. So it's important to find out what investigation was done and to get insight into whether it's actually uncollectible. I would say as soon as a committee is formed and counsel and professionals are retained, that investigation should begin. If it's listed on the schedules. Otherwise, when you start receiving information in discovery, something you should ask for is information into intercompany loans or loans to affiliates or insiders. And that's something that should be investigated right away. Now, whether that's something that's objectionable during the life of the case or something that you want preserved for recovery to creditors, that's something that needs to be in any plan document. The right for a trust, for example, to pursue those receivables. Theoretically, it could happen during the life of the case. It's not something that I personally have seen. I've more seen that right being transferred to a trust, and then the liquidating trustee or plan administrator can pursue those accounts, or the fraudulent transfer for the right to pursue those accounts. The article is important for counsel to committees and financial advisors to committees. And I think it's also important for creditors. Creditors who sit on these committees need to be aware of this and asking these questions as well. You have sophisticated parties that are sitting on committees. There are parties who sit on committees routinely, and they need to be aware of this possibility and make sure that their counsel is pursuing it. We've seen instances where there are significant assets that are deemed uncollectible, and it's important to really run down whether they're uncollectible, why they were written off. Otherwise, we've seen in recent years creditors recoveries, unsecured creditors recoveries are becoming less and less, and you have these affiliates that are surviving and thriving and no longer have to repay and are receiving a release, and that could be the difference between no recovery and something for those creditors. I mean, I think that's one of the reasons that a committee is appointed, is to investigate those things. A debtor doesn't have much incentive to sue the directors and officers who've received these loans. And the debtor might actually believe that the loans are uncollectible. And it's a matter of examining how they came to that conclusion and determining whether the committee agrees with that. So to answer your question, I think that there's possibility of conflict, but I think that there are enough other parties in the case once you've hit bankruptcy that it's going to be investigated. That's right. And I think the article is still relevant because I think that those receivables, I think in a plan and in trust documents, there should be someone, the post-confirmation fiduciary, who can collect on those receivables. It's not a fraudulent transfer if it's not been formally written off, but the right to collect on those receivables should be maintained by someone. The timing for the fraudulent transfer would be at the time that the debt was formally written off, in most instances. So it wouldn't be when the actual loan was made, because that may not have been fraudulently made. It would be when it was improperly forgiven or written off. Definitely, you'll want to look at those communications to see whether there was an agreement to write off the loan, when that happened, and why. You'll also need to look at whether any analysis was done as to the uncollectability by the company. That would definitely be a defense to a fraudulent transfer action, because if it was for reasonably equivalent value in exchange, so you would need to value that consideration to determine, I think that could be a valid defense if the consideration was reasonably equivalent. Exactly. And on a tight timeline and with often limited budgets for the committee investigation, that I think that could be a reason why sometimes these are left unpursued.